Welcome to meeting number 22 of the House of Commons Standing Committee on Finance. Pursuant to the motion adopted in committee on Thursday, February 17th, the committee is meeting to study the invocation of the Emergency Measures Act and related measures. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. So you are aware, the webcast will always show the person speaking rather than the entirety of the committee. Today's meeting is also taking place in a webinar format. Meetings and are available only to members, their staff, and witnesses. Members enter immediately as active participants. All functionalities for active participants remain the same. Staff will be non-active participants and can therefore only view the meeting in gallery view. I'd like to take this opportunity to remind all participants to this meeting that screenshots or taking photos of your screen is not permitted. Given the ongoing pandemic situation and in light of the recommendations from the health authorities, as well as the directive of the Board of Internal Economy on October 19th, 2021, to remain healthy and safe, all those attending the meeting in person are to maintain a 2-meter physical distancing, must wear a non-medical mask when circulating, and it is highly recommended that the mask be worn at all times, including when seated. Must maintain proper hand hygiene by using the provided hand sanitizer at the room entrance. As the chair, I will be enforcing these measures for the duration of the meeting, and I thank members in advance for their cooperation. To ensure an orderly meeting, I'd like to now outline a few rules to follow. Members and witnesses may speak in the official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either Floor, English, or French. If interpretation is lost, please inform me immediately, and we will ensure interpretation is properly restored before resuming the proceedings. The raise hand feature at the bottom of the screen can be used at any time if you wish to speak or alert the chair. For members participating in person, proceed as you usually would when the whole committee is meeting in person in a committee room. Keep in mind the Board of Internal Economy's guidelines for mask use and health protocols. Before speaking, please wait until I recognize you by name. If you're on the video conference, those in the room, your microphone will be controlled as normal by the Proceedings and Verification Officer. When speaking, please speak slowly and clearly. When you are not speaking, your mic should be on mute. A reminder that all comments by members through the chair. With regards to the speaking list, the committee clerk and I will do the best we can to maintain a consolidated order of speaking for all members, whether they are participating virtually or in person. This meeting is scheduled for a longer duration, and in consideration of the fact that our witnesses may not get an opportunity to leave their virtual setup, at around the halfway duration mark of the meeting, I will suspend the meeting for a 5-minute health break. Now, just before we go to witnesses, members, this is a committee business. Our subcommittee met just earlier today. And in that subcommittee, we had an opportunity to go over the schedule of a number of studies that are before us, be it the PBC,
Mr. Clerk, is Mr. Fonseca frozen for us all, or just he's in Gatineau?
Yeah, he's frozen for us all. He's had technical difficulties all day. So I believe we will have IT call him, and he will probably join us back with his phone. But in the meantime, if we have we don't have Mr. McLean, who is the vice chair. So, Monsieur Sainte-Marie, en tant que vice-président, sa deuxième
So, as the second vice chair, if you want to adjourn, you can do that. But if you want to continue the meeting, you can choose to do that. Also, it's up to you. Well, I'll start with a question. Clerk, can we, or do I have the power to suspend the meeting for a few moments until we get Mr. Fonseca back? Yes, if so, that's what we will do. Help?
So whenever you're ready, sir, you can just start the meeting again because we're suspended, and then start over with the subcommittee report.
Okay, thank you very much, Clerk. Call the meeting back to order. And yes, I apologize to everyone for the technology difficulties that I'm experiencing. As I was saying just before we bring on our witnesses, just here today, our subcommittee did, through unanimous consent, agree to our subcommittee report, which spells out a schedule to look at our pre-budget consultations, our Bill C-8, our Emergency Act, as well as our inflation study. And I believe the clerk has distributed that schedule to all members. There were a few minor changes that were made to the schedule to accommodate for a number of things and to actually make this much better. So The PBC for March 3rd will have a second meeting from 6 to 8 p.m. Now, this is if we had consent from all members to have them work through their whips to prioritize FINA over other committees to allow for that meeting. Deadline for member recommendations submission for Emergencies Act study. Members agreed for Friday, March 11th. Emergency Act study. Members agreed to add 30 minutes to 1 hour to the last witness meeting. An Emergency Act study tabling moved to Monday, March 28th. Also, shuffling the March 24th with the 21st to help out the analysts, to give them more time for that report. To have the RCMP and FinTrack this Thursday come before us, and to have the Bankers Association and looking at also Desjardins and the big five banks to see if they can come before our committee on March 7th. So, Clerk, did I capture everything?
Yes, sir, that is my understanding, unless there's a member that heard something differently.
Okay, if you could just let me know if there's any show of hands for that, and then what I am asking members for the adoption of this report.
You're getting thumbs
And
up,
Clerk,
sir.
if you.
Yep, you're getting thumbs
Okay.
up.
Excellent. Okay, thank you. Thank you very much, members. That's very helpful. And now it's my pleasure and opportunity to welcome our witnesses. We have the Canada Revenue Agency, Sophie Emberg, Director Review and Analysts Division, Charities Directorate. The Department of Finance, Isabelle Jacques, Assistant Deputy Minister, Financial Sector Policy Branch. Julien Brazeau, Director General, Financial Crimes and Security Division, Financial Sector Policy Branch. Manuel Dussault, Senior Director of Framework Policy, Financial Institutions Division, Financial Sector Policy Branch. And from the Department of Justice, Samantha Maislin-Dixon, Assistant Deputy Minister, Public Safety, Defense and Immigration Portfolio. And so we'll commence with the Canada Revenue Agency for up to 5 minutes.
Hello. Hi, good afternoon, Mr. Chair. Thank you for the invitation to appear before you today. My name is Sophie Emberg, and I am the Director of the Review and Analysis Division of the Charities Directorate within the Canada Revenue Agency. Through the clerk, the CRA has provided a copy of my full remarks to the committee's attention, which provide an overview of the CRA's specific role in this area. So in the interest of time, Mr. Chair, I will summarize my remarks by noting that the CRA's contribution is administered by two distinct areas. Through the Charities Directorate, the area that I represent, which has a particular focus on determining whether the charitable registration system is being abused, and through the Criminal Investigations Directorate, which supports anti-money laundering efforts. With that, Mr. Chair, I would be pleased to answer any questions the committee may have.
Thank you for your opening remarks. And Clerk, did you say that we had opening remarks from some of the other witnesses?
No, there are none.
There are no further remarks. Okay, so we will move to members, and I guess I'm just looking to see. I've got. It's MP Lawrence from the Conservatives. Each party will have up to 6 minutes for their questions in this first round, and I've got the Conservatives and MP Lawrence up for 6 minutes.
Thank you, Mr. Chair, and thank you for fighting through your technological difficulties. We've all experienced that throughout the pandemic there. I want to start with a general statement, and I will welcome anyone who wishes to respond. I suspect that it's the Department of Finance that would be best positioned, but if anyone from the witnesses wants to respond, that is great. The invocation of the Emergency Measures Act has given government the right to freeze the bank accounts of individuals, exposing individuals to potential financial ruin. For as the Minister of Justice said, supporting causes the government does not believe acceptable. When you freeze someone's bank account, you are effectively removing them from society. They may not be able to pay for food to feed their children, put gas in their car to go to work, or even to pay for electricity to heat their homes. I want to walk through step by step the emergency measures orders respecting the financial provisions, so that Canadians can clearly understand the financial implications, because I believe there's a great deal of misinformation out there right now. So we'll start here. So, pursuant to the emergency measures order, financial institutions can effectively debank someone as a designated person. Under the emergency measures regulations, a designated person is defined as anyone who has participated or supported an unlawful assembly. This gives the government incredibly broad powers. As Professor Paul David said, the debanking provisions were so broad that literally a clerk at a Quickie Mart who sold a propane canister to a protester could have his accounts frozen. Witnesses, members, Canadians are afraid. Members of Parliament have received thousands of calls and emails from Canadians who are concerned that even a small contribution to a then legal cause could result in their financial ruin. I'm going to ask the witnesses some clear and succinct questions. I would very much appreciate their response, not for me, but for the rest of Canada. To the witnesses, what specific acts could have or would result in the freezing of a bank account? You're on mute.
Madame Jacques, vous êtes en sourdine.
You're on mute.
I apologize, Mr. Chair. What would lead to the freezing of a bank account under the order that came into force on February 15th would be if someone is funding directly or indirectly illegal activities as they are set out in the regulations that came into force. So for example, if somebody was, giving money to a third party to enable them to participate in the illegal blockades that were occurring on the Hill, that person could be captured.
So to be clear, if a passerby gave an individual a cup of coffee, they could have their bank account frozen.
No, not a cup of coffee. We had a process in place. As you may know, the RCMP, the process had two prongs. The first one was our colleagues in the RCMP had a list of individuals and were shared with the financial institutions. So that's one way in which those individuals could be captured. The other one is if a financial institution using their algorithm found that there were any issues and further to verification found out that they were involved in
So my apologies. I don't mean to be rude, but my time is short there. So, but just to be clear, a financial contribution to either through a crowdsourced platform or directly could result in their bank account being frozen.
Yes, yes.
So they didn't have to.
To the extent.
They did not have to actively be involved in the protest. They didn't have to be here in Ottawa or at one of the blockades.
No, not themselves. It could be indirectly.
So if someone gave $20 to the Freedom Convoy through a crowdsourcing platform, they could have their bank account frozen.
if that person gave the money after February 15th. It is possible, although very unlikely in view of the circumstances. And I say this because the banks, the financial institution relied heavily on the information that was provided by the RCMP, further to their own internal processes and verification. And so they approach it from basically a risk-based approach. I would, although not impossible, that someone who gave $20 be captured and have their bank account frozen. I found that scenario, I think it would be in rare circumstances.
But it is possible.
It is possible.
So to my mind, the order is fairly clear. There are some caveats on it, but it says for an assembly. And the assemblies have now been disbanded. Have we stopped freezing bank accounts?
Yes, we have. And as a matter of fact, and I don't know if this information has been shared with a member of the committee, but yesterday, and I may want to leave the RCMP speak to this. I don't know if they're coming before you, but they did share a list with financial institutions, and financial institutions are unfreezing accounts. As of yesterday, they started yesterday to unfreeze accounts.
And how, just following up on that, and thank you for sharing that information. Following up on that, if you are an individual and you want your account unfrozen, how do they appeal? Who do they talk to? Whether it might have been frozen by mistake or in accordance with the Act.
Yes. So individuals whose account have been frozen, whether it mistakenly, but I haven't heard of any such incidents, to contact directly their banks, customer service, to do a first verification. And if the bank didn't feel it had the proper answer, could reach out to the RCMP to validate some of the information.
Thank you. Thank you, MP Lawrence. That's the time. We are moving to the Liberals. MP Zarowitz for 6 minutes, please.
Thank you so much, Mr. Chair. And I want to thank all the witnesses for being with us today on such short notice. And thank you so much for the important work that you do. My first question, just because I think that just for those who are listening, I think we should just establish that when the Emergencies Act was declared, and we announced the declaration of a public order emergency under the Emergencies Act and the disruptions, the border blockades, and the occupation of Ottawa's downtown core. And under that public order emergency, there were a series of measures around stopping the flow of money that might actually be funding any of these public order measures and events that were taking part across our country. And perhaps directing to the Department of Finance, can you give us a brief rundown of what the Proceeds of Crime, and so Crime, Money Laundering, and Terrorist Financing Act, what it allows for, and what gaps it has that the invocation of the Emergency Act addresses?
Yes, Mr. Chair, thank you for the question. So we realized that there were gaps in the system as to what our colleague at the Financial Transaction and Report Analysis Center of Canada, FINTRAC, could capture. We realized that it didn't capture crowdfunding platforms, not all of them, and payment service providers. So when the order came into force, crowdfunding platforms and payment service provider had to register with FINTRAC and report any suspicious transaction to FINTRAC. This was in order to help mitigate that these platforms received illicit funds and increase the quality and quantity of intelligence received by FINTRAC. And also that allowed to make more information available to support investigations by law enforcement.
Okay, thank you. So just in layperson speak, basically cryptocurrencies and crowdfunding platforms were not included under the Proceeds of Crime and Terrorism Financing Act. And so that was what was put into place in terms of the emergency orders. Is that correct?
Cryptocurrencies were already covered, although what was not covered is the reporting by crowdfunding platforms and payment service providers. And I don't know if my colleague Julien may want to add to this question. Julien Brazeau.
Just very quickly. Okay, I don't see anything.
He
So
may not be there.
okay,
right.
yes, I don't see him there. Okay, my next question is, can you confirm that making these powers permanent cannot be done unilaterally and would require legislation?
To make these permanent, we have two options. We can do it by way of legislation, which includes regulation. So we can make these permanent by way of regulations.
Thank you. And can you also confirm that the powers are not retroactive and it only began after the Emergencies Act was declared?
Yes, I can confirm that it is not retroactive. We received many questions from concerned individuals who thought that it would retroactively apply, but it does not.
Okay, thank you. We saw reports of truckers leaving the convoy voluntarily after being warned by their insurance companies that their insurance may be suspended. Was the intent of the program, was this the intent of the program, and do you have any further information on the success of these measures?
Well, certainly the intent of the program was to certainly responsibilize and dissuade people from using money or their vehicle to participate in these illegal blockades. I do not know if any trucker or individual had their insurance suspended. I think the goal was to ensure that people left on their own volition, firstly.
Okay. So, but you wouldn't know whether or not there was an influence of the fact that their insurance, they could lose their insurance, that had an impact on them actually leaving.
I certainly think it did. I mean, a lot of these people that were involved, I mean, trucking is their livelihood. So to understand that your insurance could be suspended, I think would be an incentive to stop the illegal behaviors.
And then just maybe one clarification, my final minute. My understanding is that government actually has a limited role in terms of acting. Really, it's enabling this information to be shared with financial institutions and RCMP from FINTRAC in order for them to have a role to enforce.
Pardon me, I could not hear clearly your question. Would you mind repeating, please?
That's okay. Of course. With these emergency measures in place, and particularly as it relates to what we're currently talking about, the federal government has a limited role in terms of enforcing. It really is enabling RCMP and financial institutions to receive information from FINTRAC in order for them to actually enforce and take action.
That is correct. Privacy was of course, in the fore and of concern. We want to respect the privacy of individual and respect the Privacy Act. So the order allowed for information to flow from the RCMP and some institution directly to the financial institutions. So not through the Department of Finance. That is correct.
You.
Thank you so much.
And thank you, MP Zarowitz. And now we are moving to the bloc and Monsieur Samari for 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair. And I too would like to welcome all the public officials who are here today and thank you for all of the efforts in these exceptional circumstances. I have a first question for the Department of Finance, probably for Madame Jacques. The order does not give many details about the mechanics and the criteria for freezing funds. When we read the order, there's not many details. So have you communicated more specific details to the financial institutions? Certainly. As soon as the order entered into force, we took measures to communicate on a regular basis with the financial institutions. And some of our discussions are on a daily basis to make sure we can help them to implement the order and to answer their questions. Thank you. So you've talked about discussions. Have you actually sent written criteria to the financial institutions so that they can correctly implement these possible freezing of funds? No is the answer. We haven't sent details or written information, but we have made ourselves available to answer any questions that may come up from the various entities about implementation. Moreover, we will indirectly, the RCMP shared information directly with the institutions so that they were able to implement the order. Now, obviously, I'm very worried about the government's action on this. If I've understood correct, there's been no written passing of criteria. It's just been on a verbal basis. That then leads to lots of possible different interpretations. We know the order gives immunity to financial institutions, but afterwards, if the criteria just passed on verbally during discussions, that does lead to differing interpretations. And of course, for me, that is problematic. I'd like to come back to that a bit later, but for the moment, I'd like to talk about vehicle insurance. Has there been any written advice that's been sent to the insurers for this question of suspending vehicle insurance? No. No written advice has been sent to the insurance companies. Okay, so from my point of view, once again, there's a problem in terms of the government. Perhaps I could clarify here. The way in which the order has been drafted means that it's the entities that are responsible for implementing the order. So, factually speaking, the entities were responsible to ensure that they meet the requirements set out in this order. We answered their questions, we made ourselves available to them, but they also consulted their own legal departments to make sure that they were meeting the requirements laid out in the order. Yes, I do understand that. Thank you for those specifications, but that causes an enormous problem for me because it's vague in the order and it's open to interpretation. If we don't add written specific advice, there's a risk of derailment. For example, which advice did you give them about insurance to ensure that truckers were able to leave without their license being suspended? Did you suggest them you wouldn't suspend the license while they were leaving? No, I didn't suggest anything. I'm with the Department of Finance. The information was given by our RCMP colleagues. They are the ones that had certain information that they shared with the entities that were implementing the order. So the Department of Finance was not part of that exchange of information. But to come back to the insurance companies, if they got information and I can't validate that, it would be up to them to decide whether the holders of license were actually in violation. My concern here is the implementation of this. If the trucker was leaving with his truck and in order to leave the convoy, he's no longer insured if he caused an accident, then the order would actually penalise the potential victims of that accident. We've got the no fault in Quebec, at least with the SAAQ, but in Ontario you don't have that. So with the order, I do think it could very much penalise victims. And then I've got that was a comment, and I'm going to go on to a question. In Quebec, we've got the SAAQ, and it's universal and it's government run. And is the SAAQ also covered by this federal order? The SAAQ is not covered as such because it's an insurer as well, even if it's a government insurer. Yes, the insurers that are covered by the order had to take action if they knew that a vehicle, for example, was being used in order to participate in legal blockades or those assemblies that took place. And thus, they had to suspend. They had the information and they had to suspend the insurance of the truckers. I don't know if that's happened or not, but I can let you know that by sharing the information, there would have been notices sent to the truckers if their insurance was suspended in order to allow them to leave. There were many notices that were given to the truckers by the RCMP. It's time to leave. Now, I understand. How did insurers know that they were insuring a trucker that was there? Was it the RCMP that sent them a message and asked them to suspend the insurance? Well, I can only believe that if there was an exchange of information, that would no doubt have come from the RCMP, but I would prefer to leave it up to the RCMP to show the responsibility to answer that question, because the Department of Finance was not involved at that stage in the process. Thank you very much, Mr. Saint-Marie.
And now we're moving to the NDP and MP Blakey for 6 minutes.
Thank you. So maybe just following up along that same line of question, whether it's for insurance companies or for financial institutions more generally, what are the sources of information that they might have had? We know the RCMP is one source of information. What would be other sources of information under the powers granted that they could action any kind of freezing of accounts or suspension of insurance on?
Yes, as I was mentioning, so it was either, as you just mentioned, through the RCMP, but they could also use internal information using their software, their algorithm, to see whether there was any activities that were related to these blockades. But we're not privy to what they found, and they would vet the information. And I'm sure if they had questions, they could have maybe contact with the RCMP, and the decision was theirs to make if they wanted to freeze the account.
Okay. And so when that happens, are people notified that that a freezing of an account that's occurred in their case is a consequence of the mandate under the Emergencies Act?
I don't know whether the financial institutions advise their clients. I'm not sure if anything was posted, but certainly I believe in the media, it was clear that this was an potential impact should somebody want to finance illegal activities.
So certainly, you know, I do think it was publicly communicated in advance that this could happen. But I mean, in the event that it does happen, are people told that their account is frozen as a consequence of the emergency orders, or are they left to wonder? What right do people have to know whether what's happening to them is a consequence of emergency orders, or whether it's happening under some other kind of authority?
Yes, I do not know if any such notice were provided. So if somebody's account is suspended, whether because of the order or other reasons, or other court orders, as we know, the Ontario Superior Court also issued an order to freeze accounts. So as to whether an individual would know why their account was frozen, I do not know if any notices were provided. I'm not.
Okay, so there's no obligation to provide such a notice.
Not
coming from the government or the emergency orders. If there were, it would be a result of the internal policy of the organization that froze the account or suspended the insurance.
That is accurate.
Okay. Is it possible for government to require financial institutions who have frozen accounts under these authorities to require those institutions to offer such a notice?
I presume it could be done legislatively. I may want to turn to my colleague Manuel. I've not done that research. I don't know if there's any more specific answer that Manuel Dussault can provide in this regard.
Well, it's just thank you for your question. It's just an initial reaction. I agree it might be possible, but it's something we'd have to look at.
Okay. I mean, I think that the public interest value in that kind of policy would be that there does seem to be confusion about why some people's accounts are being frozen right now. There's the appearance that some folks feel that their accounts are being frozen as a result of the emergency orders. In some cases, that does not cohere with what we're hearing from government. A requirement that when those accounts are frozen as a consequence of the institutions fulfilling their obligations under the emergency orders, that would help people know in a very kind of crystal clear way whether the emergency orders resulted in their account being frozen or whether it was something else. So I do think that's something for us to be considering as a committee, and for I hope that officials might consider taking back to government, because that's one relatively straightforward way that I think we could provide a lot of clarity for Canadians who are wondering. I am curious to know what the smallest denomination of donation or contribution has resulted in a freezing of an account so far?
I would not be able to provide you that answer. The information was strictly exchanged between law enforcement, the RCMP, and the banks.
Is that something it would be reasonable to expect the RCMP to know?
Well, I mean, if the RCMP exchanged information with a bank, as you saw under Section 5 of the order, there was a duty to disclose to the RCMP or CSIS. I do not know if they have the details of the amounts. I was not privy to the information that was shared. So I do not know the answer to that question.
Okay. I'm looking to the chair just to know how I'm doing in terms of time.
You got about a minute, just under a minute.
Okay. So we would be looking to the RCMP for information on how low the threshold is. I mean, I think seems to me that there are maybe two elements to the financial measures here, and I'm interested for your input on this. One clearly was before the streets in Ottawa were cleared, this was meant to create a tool to put pressure on people to leave the occupied area and to go home. Is that the only purpose of the financial measures, or is there also some follow-up around some of the organizers and groups and activities that they may have been involved in that represent a more ongoing threat to national security?
Short answer, please.
From my perspective, it was solely to ensure that people stop funding illegal activities.
Okay. Thank you. And thank you, MP Blakey. We are moving to our second round members. In this round, we're starting with the Conservatives, and I have MP Chambers up for 5 minutes.
Thank you very much, Mr. Chair. Thank you to our witnesses, and thank you for your answers thus far. I think my colleagues have asked some excellent questions with respect to process, so I would like to continue to focus on process. Can you provide the committee with a number of how many accounts and individuals have been frozen to date?
All I provide you is, yes, an aggregate. So it would be over 206 accounts, but I would not be able to tell you exactly how many entities. So it's possible that one person or one company had more than one account. So I think we're close to, yeah, it's about maybe over 206, 210.
Okay, thank you. And so that also confirms the next question, which is an individual could have more than one account affected. So it could be a savings account, a checkings account, or a mortgage, additional products that a financial institution would provide. Okay.
That is accurate.
And I've heard some discussion here today, but also in the media, this notion the banks make a final determination, a financial institution makes a final determination as to whether an account is frozen, and they liaise directly with the RCMP or some other sources. Is that correct?
That is correct, yes.
Okay. Are you aware of any circumstances where a financial institution has provided evidence from the RCMP or other sources where the bank has not frozen the account?
I do not know. That's not we would not receive that information.
Okay. Prior to an account being frozen, I'd like to pick up on my colleague, Mr. Blakey's line. Prior to an account being frozen, are you aware of an opportunity for an individual to either be notified or to make any representations to the financial institution or law enforcement?
No, not to my knowledge. So not under this order.
Okay. So I hope you can help me understand. One of the things we've been told about this act is that it complies with the charter.
Yes.
And saying something complies with the charter doesn't necessarily make it true. It's in the preamble of the Emergencies Act. But the ability for a financial institution, which by the way is a third party, to act as the judge and the jury without the opportunity for an individual to make any representation, I'm having a hard time understanding how that is compliant with the charter.
I understand your question, and I will give a partial answer and maybe turn to my justice colleague. This was considered when the order was drafted, and that is why you will see under Section 3, duty to determine, what was inserted in the order was an obligation to the financial entities to determine on a continuing basis whether they are in possession or control of property that is owned, held, controlled by or on behalf of a designated person. That section was inserted specifically for that purpose, to be compliant with the charter and provide and ensure that financial institution review on an ongoing basis. So let's suppose that your bank account was frozen. You're the wrong person. You were not involved. You have the opportunity to go to your institution, say, or me, Isabelle Jacques, I'm not involved in the illegal activities. I did not finance any activities, and I need to be, my account was frozen by mistake. So you had the opportunity to do that.
Okay, I respect that answer, but just we're short on time.
Yes.
With respect to due process, I mean, that is not like prior to a determination being made. I mean, there's no opportunity for an individual to provide any representation. I mean, to me, is a violation of the charter and due process. The second question would be, has there been any information or direction given to financial institutions about what information and how long they can keep information on file on these individuals?
On the information piece, not to my knowledge, but the information was shared for the financial institution to make a determination. But on the charter issue, and again, I may want to turn to my justice colleague, but one need to remember that these are extraordinary measures. They are temporary. In time.
Correct.
But I think if the behavior stops, so I apologize. If the behavior stops, then there was an obligation upon review to unfreeze the account.
Thank you. And that's the time. MP Chambers, we are moving to the Liberals and MP Baker for 5 minutes, please.
Thank you, Chair. Can you hear me, Chair? Yeah, I'm having some technical difficulties, so if I cut out, I apologize, but that's why it would be happening. It's from some members that there have been freezes on individual bank accounts for merely donating or purchasing merchandise for the blockades. The RCMP actually put out a statement, I think, in part to kind of clarify this issue. And I'll just read it. It's very brief. This was yesterday. Under the Emergency Economic Measures Order, Emergencies Act, the list that was provided to financial institutions, including identities of individuals who were influencers in the illegal protest in Ottawa and owners and or drivers of vehicles who did not want to leave the area impacted by the protest. At no time did we provide a list of donors to financial institutions. We are now working with the banks to build a process to address the accounts that were frozen. So I thought that's important to clarify, because that, the RCMP is trying to clarify there who are the individuals on that list that they've provided to financial institutions. And again, they're saying they're influencers in the illegal protests and owners and or drivers of vehicles who did not want to leave the area. I think it's important because it speaks to the scope of who's being targeted by the RCMP's list, who's on the RCMP's list, and therefore who's being targeted by the financial institutions. Could you clarify? So my question is, could you clarify when the measures were implemented and whether or not they apply retroactively?
Thank you. The measures were implemented on February 15th, and they do not apply retroactively. So going to your example and understanding the information that was shared by the RCMP with the financial institutions, I must admit, and based on the knowledge that I have, I think it would be unlikely that someone who gave, and I can't imagine certainly someone who gave $20 3 weeks ago or even $20 post February 15 that they would have been captured by a freeze. It's not impossible in view of the order, but in view of the exchange of information and the focused approach that was taken to stop the illegal funding of these activities, it would appear to be unlikely that this occurred, but not impossible.
Yeah. And could you speak to, you were earlier answering a question from another member about the number of accounts that have been frozen. Could you repeat that for us, how many accounts we're talking about? And if you have that information, because there have been public reports on this, is the amount of money that's involved?
Yes, and as you may know, I mean, that information has flown over time, and now that banks are unfreezing accounts, it may not be accurate, and I do not have additional information. So the numbers must be lowered today as we speak, but to my knowledge, it's over, I would say, over 206 accounts, and the total value, the latest number I have was approximately 7.8 million.
Okay, so if I took that 7.8 million and I divided it by the 200 accounts, roughly, and I'm doing this on the top of my head, this sounds like about an average of $35,000. Am I in the ballpark?
I'm not even able to, well, if you do the math, yes, but I'm not able to tell you individually. We received only total amounts. The Department of Finance did not get, we know that those accounts are a personal and commercial account. So it's a mixture of the two, and one person may have more than one account. So it could be that, close to, 60, let's say, entities with a certain number of accounts and different products that they have. So I'm not able to tell you even the value.
Understood. I think I have about 30 seconds left, Ms. Jacques. So I'll just ask you, did banks and financial institutions have the ability to freeze accounts before the Emergencies Act was invoked? And if so, under what circumstances?
Yes, on an ongoing basis, banks certainly can freeze accounts if they are concerned that there's fraud or illegal activities. And as you know, on an ongoing basis, the police officers, RCMP, may be in contact with banks, and they take measures, sometimes to protect consumers. They freeze the accounts if they see some abnormal activities in the bank account. Also, as we mentioned, there are court orders that were issued by the provincial courts. So it's possible that they were also freeze that occurred independently of the actions under the order.
Thank you.
Thank you. Thank you, MP Baker. We are moving to the block and Monsieur Saint-Marie for 2.5 minutes.
Merci, Monsieur.
Thank you, Chair. Ms. Jack, I understand there was no written government directive that was sent to the financial institutions to indicate what needed to be blocked or authorised. There were just verbal instructions given. Now, verbally speaking, did the government transmit instructions about joint accounts, alimony, or rental, heating costs, etc.? There were no written instructions, but what was shared, and once again, I think you need to ask the RCMP. I know they shared lists with a certain amount of information. These lists were shared with the financial institutions in writing. In terms of joint accounts, absolutely it's possible. There were questions about this. If there's a person who's involved in the illegal blockades on the Hill, then it's very possible that a joint account was suspended. Thank you. So, according to your knowledge, has the government borne that in mind? If the joint account is blocked, that means that there could be a victim involved who hadn't actually committed a reprehensible act. I understand what you're saying, and it can seem to be a bit severe, but it was a simple solution. The person just had to stop participating in these illegal activities as described in the order. So the suspension was quite rapid. And for alimony or custody payments, the government didn't send instructions. Was it the RCMP that decided to interpret these instructions? No, that's not what I wanted to say. Obviously, the RCMP possessed information about the individuals and entities that were participating in the illegal blockades. So that was the information that was shared with the banks. So for child support payments, they just said we'll freeze the account and they cannot pay the money, for example, to the mother of the child, and the government didn't decide to actually execute the details of this order. Well, on this specific question, we had discussions with banks, and of course, they were able to exercise their judgment to make sure that these child support payments considered to continue. So there was a non-verbal directive that was emitted by the government. No, it wasn't directive, but there was certainly a discussion on this. Okay, thank you very much. Thank you.
MP and MP Blakey for 2.5 minutes.
Madame Jacques, you've said a couple times now, and you can correct me if I'm wrong, but that the accounts were frozen and the goal was to stop participation in the occupation in Ottawa or on blockades, and when that behavior ceased, the accounts would be unfrozen. So financial institutions presumably received information from the RCMP and on that basis froze accounts. What's the process for financial institutions knowing whether the behavior that's the subject of the order has ceased or not?
Well, likewise, the reverse is true. Information, and again, I should turn to my colleagues at the RCMP. I don't want to misspeak on their behalf, but information was shared by the RCMP with financial institutions, and we were informed yesterday by financial institutions that they were unfreezing the accounts.
Okay, so at the moment, subject to the time it takes to implement that order, there should be no accounts frozen under the emergency order.
I don't know that there is none unless the financial institution had different information other than what was shared by the RCMP, and I'm not able to tell you, but I would think that the vast majority of accounts are in the process of being unfrozen.
Okay.
And it's subject to any new information that the RCMP may have, but to my knowledge, that's the status of the situation actually.
Okay. Would there be any other law enforcement agencies that are contacting financial institutions directly with intelligence on whether people are behaving in ways prohibited by the order? So whether that's CSIS or local law enforcement in Ottawa or other places where there were blockades?
It's certainly possible. It's prescribed by Section 6, disclosure of information for provincial territorial institution to disclose information. I do not know, and I'm not able to tell you whether any of, if there was any communication between those provincial or other institution with the financial institutions.
So if other if law enforcement agencies other than the RCMP were communicating with financial institutions, there's no obligation to inform the federal government that kind of reporting has occurred?
Well, as you saw under Section 5, the entities must disclose without delay to the commissioner of the RCMP. So the information would come back, but I'm not.
So your
privy
expectation
again.
would be your expectation would be that information would be captured in the RCMP reporting.
Yes, that would be my expectation.
Thank you, and that is the time, MP Blakey. Thanks. We are moving to the Conservatives for 5 minutes. MP Stewart, you have the floor.
Thank you, Mr. Chair. Can you hear me? Can you hear me?
Yes.
Yes. Okay. Thank you. So, I mean, what we're seeing here is a complete suspension of civil liberties, number one. And the Prime Minister often talks about which things are acceptable to him and which things are unacceptable. Obviously, every other protest that blocked off a road or a trade route was acceptable because he didn't follow the money on any of those, whether they be climate crisis protests or any of those ones that he obviously supported. But he's willing to suspend civil liberties and put Canadians' lives and freeze their lives and put their banks on hold right now because single mothers and little old ladies and lots of people in Canada supported this, rightly or wrongly so. Now, I want to know something. Is it, I thought I heard that this wasn't, that it was not retroactive. Are these bank seizures retroactive?
Could you precise what you mean by that? I mean, no, the order is not retroactive. So they could not use the fact that a person gave $50 5 weeks ago to freeze the accounts.
So what's the first date that somebody donated to this cause?
Pardon me, what is the first date that a person donated? I would not have the information. All I can
That's
tell you.
interesting because we have CRA in the Department of Justice, the Department of Finance. We're suspending civil liberties and you don't have the information.
No, what I mean is the first effective date of the order was February 15th. So financial institutions could not have used information obtained, previously to freeze accounts. But I will turn to my colleague.
Okay. No, I have another question.
Oh,
so
okay.
There was one individual in my province that donated quite a sum of money, I believe, like $75,000 or something like that. So if that individual donated that money, say 3 weeks ago, what happens to that money and where does it go?
So I do not know where he donated the money, but if the money was under, he donated the money, your constitution, but I don't know to which entity he gave the money, but let's say that it ended up in the financial system and that a bank could freeze the account of the person, let's say it's a person, company, I don't know, that received the fundings, then it would have been frozen if captured. And now that the activities have stopped, would be unfrozen. And remain in the account. It wouldn't go anywhere else. It stays in the account.
My question was, if somebody donated money before the 15th of February,
yes,
what happens to it?
It should be where the person gave it. I mean, it shouldn't have been captured.
So where does it go? Does it go back to the person
where
who donated
where
the
did
money?
that person gave the money? Who did he give it to?
I have no idea. I just seen it in the newspaper. I mean, let's say it was GoFundMe. Let's say somebody made a GoFundMe donation.
Okay.
Let's face it. No, let me keep talking.
Yes.
You can make a donation to GoFundMe from anywhere in the world, so long as you have a Visa or a MasterCard or something. That's my understanding. So let's say somebody made a donation, I don't know, February the 7th or something. Where does that money go?
If that person, to take your example, gave it to GoFundMe, it went to the GoFundMe fund. And as you may know, I mean, from the news that I read, they returned the money back to the donors on their own. The actions GoFundMe took was, I believe, their own, as they may not have been comfortable with the ongoing activities. But I'm not the expert and I don't have firsthand information. But I see that colleagues have their hands up.
Yeah, I have another question though.
Point of order, Mr. Chair.
Yeah, I was going to do that.
Point of order.
Yeah, sorry to interrupt my honorable colleague. I'm just wondering.
Point of order. You're not.
Point of order. Go ahead.
I would like to ask the clerk to ask the interpreters if the interpretation is coming through, because it's not coming through very clearly on my end.
This is a stall tactic because they don't like the questions.
Mr. Stewart, if we can ask the interpreters.
Oldest trick in the book, isn't it?
Is Mr. Stewart coming through? Do you need more? You need more audio from Mr. Stewart? Is that what I'm getting from the interpreters? Yes. Yes. Okay. So more audio from Mr. Stewart, please, for the interpreters.
Okay, so if we could if we could slow down the pace, MP Stewart, in terms of the questions, and
how much time do I have,
just
Mr.
in the
Chair?
crosstalk to help the interpreter. You have right now 22 seconds. I did stop the time.
Thank you. I just wanted to say that the Canadian government gave a settlement to Ulmer Cotter, $10.5 million, who shot and killed our allies in the United States, Trudeau said that we can't water down Canadian citizenship. A Canadian is a Canadian is a Canadian. But now we're picking.
Point of order,
words and
Chair.
words or-
Point of order.
Point of order.
Point of order.
Point of
Chair.
order. Yes, point of order.
Yeah, relevance at the and there's many instances where one could have called point of order. The our colleague was interrupting the witness from answering, held off because it seemed to have been corrected. But at this point, especially, how it's relevant to the topic at hand really is beyond me.
Yep, we will stick to the emergency measures.
Appel au règlement, Monsieur le Président, appel au règlement.
Oui.
Point of order. I'd like to add something to this. For some meetings now, certain MPs raise a point of order to say that the other MP is out of order. And normally in the chamber, in the committee, we have quite a lot of flexibility, and we have to allow them to come up with two sentences to arrive at the subject. Otherwise, we're not able to have a real debate. So do make sure, Chair, that when there's this point of order to say that a colleague is off topic, please let them talk and give them a bit more room for manoeuvre and latitude, because there's no point systematically interrupting the debate on this subject. Thank you.
Merci, MP Sainte-Marie.
Thank you, MP Sainte-Marie.
Some leeway. We were well over the time then with Mr. Stewart. So, but I take your point. We are moving now to the Liberals and MP Chatel for 5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair, and thank you to the witnesses who have come before us today. And thank you for your very clear answers. I just want to ensure that I've quite grasped the question from Mr. Stewart. It was very interesting. He was asking about the funds that went to GoFundMe that were paid before the 15th February. What happens with these funds? And I think the answer was also quite clear. In the media, we've read that GoFundMe was going to return the money directly to the donors. So thank you very much for that answer. Now turning to Ms. Jacques once again. You're giving very specific answers to these questions, and it's very much appreciated by the committee. We've talked about rendering certain measures on a more permanent footing compared, or rather allowing FinTrack to be able to receive information about certain payment service providers that are being used. But in the Money Laundering and Proceeds of Crime Act, we know already that certain banks and financial institutions are already obliged to make declarations and to report to FinTrack. And the emergency order are now inviting the crowdfunding platforms and payment service providers to also report to FinTrack. So can you confirm that if we want to fill this legal vacuum that existed beforehand, how are we actually going to do this exactly? Can we use legislative means as we've done since the year 2000, when the Anti-Money Laundering and Proceeds of Crime Act, and can we fill this legal vacuum? I was surprised to see that we had this vacuum. I think we filled some of this vacuum in 2018 when it comes to cryptocurrencies. They're now covered, but now it does seem that the crowdfunding platforms are being used for illegal purposes. So if we could have your answer on that now, please. Yes, we've worked very closely with our colleagues in the Justice Department, and we can actually do this by legislation to fill that legal vacuum on a permanent basis, or by regulation, and we're working on that for the moment to ensure that we can fill in this gap to cover the crowdfunding platforms and the payment service providers, so we can fill that gap on a permanent basis. Thank you, Ms. Jack, and I imagine we're not the only ones in this situation. Are there discussions in the FATF? Are there discussions in FATF on this? Financial Action Task Force. I'm afraid Ms. Jacques is frozen. Excuse me? Yes, I know that you are going to talk with our colleagues with FATF, and perhaps I've got a colleague online that can add something, but we do participate in these famous FATF meetings, and we always want to try and improve the measures that are currently in place. Thank you. Then another point. Personally, in the comments that were made by the government when the emergency order was adopted, the Prime Minister said that in fact certain activities were not covered by the Act, and that's rather concerning. So can you talk about some of these gaps and what needs to be filled in the longer term? In terms of gaps, I think it was in terms of the information that was missing because the crowdfunding platforms and payment service providers were not included in the money laundering, the PCMLT-FA, but now we've widened the requirements. So we think that now we've got more information that will be gathered, and we will continue to review the measures that are in place to see if we can go even further. But we're going to work very closely with FinTrack on all this. And of course, there's a link with the work that's already being carried out on the notion of the question of beneficial ownership, because where are these funds actually going when they're donated? Or rather, where did they come from? What's the origin of these funds? We're very concerned about interference from certain foreign donors. So will we now be able to see this and track this? Perhaps it's a question more for FinTrack and also for the industry department. I think that the department that's responsible for this, but we're certainly working with them, and I think that that will also help us. Thank you.
Thank you, MP Chattel. We are moving members to our third round. And in this round, we have the Conservatives up for 5 minutes.
It's me, correct, Chair?
MP Lawrence?
Yes, I'm ready to go. Thank you. Yeah, thank you very much. My questions will once again be for the Department of Finance. And I want to talk about in the proclamation sub B, or sorry, sub C, sorry, my apologies. So in there, it gives you the authorization or gives the government to regulate property, including any crowdfunding or payment processing. Has that been done, or will that be done?
I apologize. It has been done via the order, but we're also looking at taking measures to do it on a permanent fashion.
Okay. You would need additional legislation, though, to do that permanently, correct?
Yes, we can do it via legislation and or regulations.
Okay. And but that would have stopped, I guess, regulation. So that's an ongoing as you're continuing to look to pursue? Okay. Thank you. And then, but the moment that the Emergency Measures Act is revoked, then that would be completed, right? You have to stop,
yes.
Right? Okay.
We have to stop it unless we have other measures in place at that time, yes.
And then the second part of sub C is to require financial services to provide to determine whether they have possession and control of property that belongs to persons participating in the blockade. That relates to the freezing of bank accounts, if I'm not mistaken. You said that you've stopped giving information to have the banks freeze bank accounts and in the process of unfreezing it. So that part of the Emergencies Measures Act is no longer required. Am I correct?
My understanding is that the RCMP, who's responsible for providing that information, has shared information with the financial sector, and that they are in unfreezing accounts at the moment.
Yeah. So
information was shared by the RCMP yesterday. And I guess they will share information on an ongoing basis. I'm not aware of any new information with respect to prohibited activities that may be ongoing.
Yeah. So Yeah, thank you. And so based on your information with the assemblies resolving, there is no longer there's no longer any utilization of that provision, and when we look at the processing of the fintech, that should really be done by a separate regulation following a study, not just as an ad hoc of an Emergencies Act after a crisis has extended. Would those be fair comments, or would you disagree?
On the first part, to my knowledge, to the extent that there are no prohibited activity ongoing, the unfreezing will continue. If there are new information provided by the RCMP, to which I'm not privy, the order is still in effect. So I have no knowledge that freezing is occurring currently, only that accounts are being unfrozen.
So just on that, thank you very much. In accordance with your understanding of the proclamation, if in fact at a pipeline there was a gathering or an assembly that was unlawful and sought to interfere with critical infrastructure, which would be a pipeline, the RCMP could submit information to financial institutions and have those bank accounts frozen right now or any time this Emergencies Act is in place. Isn't that correct?
I'm not sure that situation would apply. I don't know if my colleague Sam at Justice could help, as I was not privy to the creation of the section on critical infrastructure.
Thank you very much, and thank you for the question. So it's not that all assemblies are considered unlawful. It is the criteria that is set out actually in the emergency measures regulations. And if you give me a moment to pull those up. So the criteria set out there is the serious disruption of the movement of persons or goods, or the serious interference with trade, the interference with the functioning of critical infrastructure, or the support of the threat or use of acts of serious violence against persons or property. So it would be a factual assessment as to whether any assembly that would occur.
For example, thank you very much for that. My time is short. If for example, a environmental activist said they should blow up pipelines, and a group of assembled and they acted in a way that was unlawful, or a way in trying to attempt to break up, or like what happened in the Coastal Pipeline, that could potentially, if there was a group involved, their accounts could be frozen.
So I would have to defer to the RCMP in terms of linkages and assessment on that point.
Okay. Thank you, MP Lawrence. We are now moving to the Liberals for 5 minutes, and PS Kotrakis.
Thank you, Mr. Chair, and it's really nice to be here today once again on the Finance Committee. And thank you to the witnesses for your testimonies. You've given us a lot to think about and very clear answers, and it's very much appreciated. We've talked a lot about the freezing of bank accounts, and I'm just curious, it may be you, Ms. Jacques, or it might be the RCMP that's able to provide this information, but I'm curious to know what safeguards are in place to ensure the Canadians not involved in the blockades are not mistakenly targeted by the freezing of bank accounts. Are you aware of any safeguards that are in place?
Well, certainly the safeguard that we put in the legislation is this ongoing obligation on financial institution to review the information that they have in their possession. So if somebody was unfortunately captured, which would seem unlikely, but it's possible, the person can contact the financial institution and review the information that they have. It could be a question of mistaken identity, and the bank in question can unfreeze the account based on the information provided. If they need additional information, they could approach the RCMP as well. So in view of the way it's been set up, it seems unlikely, in view of the fact that you need to use money and you need proof that it's towards an activity that is prohibited under Section 2. I think it gives a very good basis to ensure that consumers are protected.
And thank you for that. And I'm also very interested in determining the sources of funding to make sure that, we follow the money and that, we protect our financial institutions and our democracy. So we know that leaked data suggests that nearly 41% of donations made to the convoy through Give, Send, Go came from the United States. Do we have a sense of who these donors are? I'm interested to know like what types of organizations or individuals from the US are supporting the convoy. And in your opinion, what threat do such large foreign donations pose to our democratic institutions and our national sovereignty?
Well, I do not have any information or details as to I read, of course, the newspaper and understand that there was a certain amount of money coming from other countries. I do not have those numbers. Certainly to the extent that that money entered the Canadian financial sector systems, it would be captured if it was used and provided after the order came into force, will be captured under the order, and that money could be seized. As for your broader question, in view of the fact that I don't have the information, I'm not able to assess to what extent it has an impact on the democracy.
And I was wondering, Ms. Jacques, if you earlier to my colleague, and I think it was to my colleague, Mr. Chambers, I could be wrong. With regard to the GoFundMe, and once the Emergency Act was dropped on February 15, or it went into effect February 15th, you know, you said that all the money was returned before Emergencies Act was declared. And I know that the GoFundMe was suspended as a fundraiser before the Emergencies Act was declared. I'm not sure if the funds were automatically sent back before. I just was wondering if you can clarify that point for us.
Yes, I should clarify it in the newspaper. I know that what was reported was GoFundMe decided to stop taking additional fund and that they returned the money to the original senders in their fund. All of this activity occurred prior to the order being in effect.
Okay. And the last thing, if I have time, Mr. Chair, my colleague MP Zarowitz said that in order to make some of these changes permanent, it would have to be legislated, and you agreed to that effect. I'm just wondering, would making these powers permanent have any impact on the ability for Canadians to legally donate money through crowdfunding platforms in the future?
No, not at all. And the permanent measures that we intend to take are with respect to FINTRAC and more in particularly with respect to the platforms and the payment service providers, not the part where we put in effect measures to seize and suspend accounts.
Thank you, and that is the time. Thank you, Piers Kotrakis, and we are moving to the block, and for 2.5 minutes, MP Sainte-Marie.
Merci, Monsieur.
Thank you, Chair. My question will be for the Department of Justice, and that way Ms. Jacques can have a bit of a break. I'd like to know whether you agree with the following affirmation, namely on the 10th of February last, 5 days before the entry into force of the order, Ontario obtained an order from the court to freeze the two main crowdfunding accounts for the convoy On, Give, Send, Go. And this was in application of the usual laws, and it was carried out as a result of the normal cooperation agreements between Canada and the US in terms of financial crimes. Are you in agreement with that affirmation? Yes, this procedure was carried out under a provision under the Canadian Criminal Code. Yes, thank you very much. So what I've understood then is that the order, the Emergencies Act, does not fill a legal vacuum, given that there was already something in place. Now, I'd also like to recall that for the crowdfunding platforms, the securities regulators in the province, and we've got the equivalent in Quebec with the securities regulator, and they already consider them as financial intermediaries that are subject to Quebec legislation. So I think that there's not a legal vacuum, but perhaps it's more of an administrative vacuum. The regulators need to get used, perhaps, to these new ways of doing things with the crowdfunding platforms. And here I'd like to hear from Ms. Dixon to see whether the Department of Justice is in agreement with that. Well, if I could come back to your first question, so I'm going quickly. insofar as there was a vacuum that was to be filled, it was not all of the funds that were given to illegal protests or for illegal assemblies. And then for the second question, I'm going to turn to Ms. Jacques on the question of where there may be this so-called administrative vacuum rather than a legal one. Yes, please do go ahead. Well, as far as we are concerned, in the federal government, when we were looking to see whether there was a vacuum in terms of FINTRAC, and we tried to fill in that gap to make sure that the various entities would actually be compelled to report certain transactions that had not been covered in the past. Yes, that's very clear then. Thank you. So it was covered from a legal point of view in the provinces and with the securities regulatory agencies, and there was no federal coverage because it's not federal jurisdiction. Now, I'm not aware of what's happening in the provinces, but of course I've taken note of what you've said. Yes, it's under provincial competence. Thank you.
Thank you, MP Saint-Marie. We are moving to MP Blakey for 2.5 minutes, please.
So I think there are Canadians who are concerned about their support for other political causes and demonstrations being captured under these emergency measures, notwithstanding that these are meant to be applied in a prescribed limited time frame, and with respect to one particular event, which is the illegal occupation of Ottawa and sympathetic blockades at border crossings. So one safeguard that might provide some reassurance to those folks is the February 15th date, where any contributions prior to February 15th are not covered. What other reassurances do Canadians who are concerned that their support of other political causes might implicate them in measures coming out of these emergency orders? What other reassurances do they have that this doesn't provide law enforcement an opportunity to implicate them in these measures?
Well, as you mentioned, I think that the situation here was prescribed, and you have to fall under the definition of a designated person and activities that are prohibited by Section 2 to 5. So, of course, if people want to donate for various purposes, they wouldn't be captured by this extraordinary measure.
Now, if it was the case that government required financial institutions to send a letter in the event that an account is frozen, highlighting that the freezing of that account is related to these emergency measures, then the absence of such a letter would be something that might provide additional comfort to Canadians who are concerned that an account freezing might be connected to these measures. Is that fair to say? That if there was a notification protocol, that might help put people's mind at ease?
It's possible that it would, but it's certainly not what is prescribed by the current order.
Okay, thank you for that. Pardon me. That was my line of questioning. So I'm.
Thank you very much.
I mean, I think partly what I'm driving at is I'm thinking about what recommendations that we as a committee can make in order to try and address some of the very legitimate concerns that Canadians have, not just about overreach inherent in the use of the Act itself, but overreach beyond what is prescribed within these orders. And so I think that's an important component of our oversight work as a parliamentary committee, is to try and provide recommendations for how those legitimate concerns can be addressed, which is why I keep coming back to the idea of some kind of notification so that Canadians can know that if they did have an account frozen, that they would know if it was under the authority of this order or not. If not, then they know that it's not a result of this order. And if so, they have a document that they can use to then try and seek remedies in the case that remedies are warranted.
Thank you, MP Blakey. We are moving now to the Conservatives. I on my list, I've got MP Lawrence. I'm not sure if MP Lawrence, if you're up again, but I've got 5 minutes for the Conservatives.
Sure, I'm good to go again. So I just wanted to go over. I really want to get clarity. Did MP Chambers want to go there? I see him on screen. You good, Endo?
I can go, Philip.
If you want to go ahead. There.
Thank you. Yeah. I recognize that cuts into my time. I'd just like to pick up just on the line of my NDP colleague, who I think makes some excellent points about providing some comfort to Canadians, but also some recommendations. We are making precedent with what's happening right now. And I worry when we reference political motives as a basis for some of the actions that are being taken. I think future governments may not be as benevolent, and we should think about that as future governments, or maybe have different political leanings. So I'm very interested in considering the actions we make now and applying them to the future. And look, as a conservative, I'm all for outsourcing or considering outsourcing parts of government actions, but we are looking at outsourcing parts of the judicial system with zero recourse for individuals before actions are taken. And so I fully recognize and appreciate that these issues were contemplated in terms of violations of the charter. But can I get an answer on if there was a clear violation of Section 8 of the charter, will there be an undertaking to provide this committee with the judicial opinion under which supported the decision to enact this process?
I can take that question, Isabelle. So what I can, this isn't a statute where normal charter statements are actually made. These are indeed regulations made pursuant to the Emergencies Act. The assessment that's been done, so no legal opinion would be forthcoming in normal circumstances. The measures that have been tailored are, the measures put in place have been tailored to limit any impact. And we all understand that the rights are protected, but no right is protected. There is a possibility to reasonably limit that right, and that limit has to be, of course, proportional to the objective that we are trying to achieve. So in drafting the legislation, what was put in place to deal with the really unprecedented events that we were living here in Canada, that is the assessment that was done.
Okay, so no judicial opinion will be forthcoming, but I mean, I hope you will have an opinion, because this is going to be before the courts. And I hope that we've thought through this. When we say that something, that the charter is applicable, but it seems like there's a bit of a circular argument happening here, that it is applicable, but it's not really, because there's some limits. But I mean, that's it, that's in the charter. So I'll perhaps move. I can respect that there are gaps in the current system, and the emergency powers fill those gaps. What I am concerned about is emergency powers continuing to be invoked for an indefinite period of time until those gaps are settled. So can we expect regulations forthcoming that are going to fill these gaps? And can we expect emergency powers to be invoked until that time?
So perhaps I'll start. I think we heard, well, I attended a brief yesterday where Ministers Mendicino and Lametti were briefing the Senate, and the communication at that point in time is that the assessment of whether the Emergencies Act and the regulations and order made under it continue to be necessary, and that assessment is being done on an hourly basis, is what I heard.
Okay, that's good. Thank you so much. So, Mr. Chair, with my remaining time, I'd like to, based on the testimony we've heard, I have a motion I'll put to the floor. I have circulated it to some individuals, and that reads as follows: that for as long as the Emergencies Act financial requirements are in place, that all federal departments and agencies provide a weekly report to this committee for the total number of persons and accounts, indicating the type of account and ownership of the account they have flagged or requested be frozen by regulated financial institutions, broken down by department and agency, that all federally regulated financial agencies provide a similar weekly report of the total number of persons and accounts that have been frozen using the Emergency Act powers. I will forward this to the clerk for consideration. And I would further note that we're looking at the gross and net accounts affected. So, you know, every week it could be 200, but it could be 200 people every week. But I would hope that this is something this committee could consider. Thank you very much.
Thank you, MP Chambers. And now we're moving to the Liberals and MP or PS Fragaskatos for 5 minutes. And then after PS Fragaskatos concludes, are going to suspend for 5 minutes as we are in a 3-hour session to give everybody an opportunity to have a bio break or to stretch their legs. Thank you.
Point of order, Chair. Point of order.
Point of order.
I believe a motion was moved, and so I believe that we have to debate.
It was
that
not moved. There was no motion was moved. So if MP Fragaskatos has the floor.
Just on that same point of order, if I may, Mr. Chair, can we just hear maybe from Mr. Chambers to that effect? I took his intention to be to move the motion, but I'd appreciate some clarification from him.
Thank you, Mr. Blakey. Thank you, Mr. Chair. Mr. Chair, it was my intention to put that motion to the floor. I hope that it would be something we could deal with expeditiously. I would be willing to, if we want to have a break and discuss, but it is on the floor. If we want to have the break now, I'd be happy to do that, but would hope that we could deal with that motion, perhaps on a unanimous consent.
Chair, if I could.
Oh, I think we had our hands up.
Oh, okay. I can't. Sorry, Julie. I can't see the hands up on my end.
Oh, that's okay, Mr. Chair. You're
MP Zerowitz. I apologize. Yes, I could not see the members. My apologies.
Oh, that's okay. I think
technology.
That's okay. I think Sophie was before me, so I don't mind if she's got a comment before I.
No. Actually, you were first, Julie.
No, you. Okay, Mr. Chair, I welcome either us taking the break right now or since at least I haven't seen the motion. I'd love to sort of see it before we actually discuss it. Move this to the end since this is an outstanding and excellent conversation. If that is amenable. So either after the break we start or at the very end. My preference is at the very end because I think we're actually getting through a lot of information and I'm okay to discuss this at the end if Mr. Chambers is amenable. Even the last 15 minutes, I'm happy to do it.
Sure. Thank you, MP Zerowitz. MP Chambers?
I would be open to that, just if I could get clarification that since this motion is considered to be on the floor, that it will be voted upon before the end of the meeting, then I would be more than happy to move this to the last 15 minutes of the meeting.
Any other hands up, clerk?
Yes, Mr. Chair, just echoing.
MP Chattel?
Yes, thank you, Mr. Chair. Echoing my colleague, and I would like to read it before Mr. Chamber went very fast, and I assume we don't have it in French. That's okay, but I would like to have a bit of time to read it. Thank you.
Any other hands up?
Yeah, Chair, from the floor here in Ottawa.
Yes, Fragaskatos.
Yeah, thank you. If I could suggest then, if we are in fact going to leave this motion until the last 15 minutes, if we could have a break right before that so that all members have looked at it, have discussed it, that would be helpful as well. Doesn't have to be very long.
I was on mute. Yeah, and is clerk again on the floor, or can you see any other hands up?
There are no more hands up, sir.
Okay, so it's about taking a break to have the members take a look at the motion, have a bio break, as well as I believe to have the motion in French is what we are looking for. I just want to see how the members, if you can just scan the room and your Zoom clerk, please.
There's Ms. Zerowitz.
MP Zerowitz.
Mr. Chair, just to confirm, it is in French. I have sent it to the clerk. I have also sent it to my colleagues, Mr. Fragaskatos, as well as Ms. Chattel, and I believe Ms. Zerowitz would also have it in her P9 account as well. And as I said, I would be, I don't know the rules here, so just look for clarification. That this motion is on the floor, would definitely agree to putting it at the end of the meeting, subject to confirmation that a vote will be held on this motion during this meeting. So if my colleagues can agree to that, I would be more than happy to discuss.
Yes, I cannot see you, but if
Ms.
any
Derowitz
hands
has
up,
her hand up,
clerk?
sir.
MP Zarowitz, and I apologize. Yeah.
It's okay. I'm giving you double peace, Mr. Chair. So just a couple of comments. One is, I think what we're agreeing is because we're at halftime, we're doing a 5-minute break. Then we're coming back and hopefully we'll continue the discussion because we're getting excellent information. Then we'll stop at 15 minutes prior to the end. And I think we were going to take a 5-minute break at that point to sort of just pause to sort of make sure that we're all on track with the motion in terms of within ourselves and have reviewed it. And then I think we're going to come back and debate it until there is a vote. And so if that's, I'm in agreement with that. And I hope that that is good for everyone else.
Thank you for encapsulating everything. MP Zarowitz, MP Chambers.
In the interest of compromise, I would agree to the 5-minute break now, but I wouldn't recommend we have an additional 5-minute break at the end of the meeting, but I think we could do the 5-minute break now. And I'd like to save some time in case there is some discussion that we need about this motion, because I am open to amendments, but I would like to make sure that we get this dealt with expeditiously.
Okay. Any other discussion? Any hands?
Ms. Chattel has her hand up.
MP Chattel.
Mr. Chair, yes, I think just welcoming the spirit of compromise and amendment, and thank you again for the wonderful translation. Thank you. I received it both French and English.
Okay, merci, MP Chattel.
Thank you, MP Chattel.
Clerk, again, I look to you.
There is no more hands up.
No more hands up. Okay, so we will suspend at this time. We'll take a 5 minutes or so, and we'll see the members back in about 5-ish minutes. Thank you. members yet, Will, so we move into the motion at about 5:15. Witnesses today, and I've got Mr. Fragascatos up now for 5 minutes.
Thanks. Thank you very much, Mr. Chair, and thank you to the witnesses. Before I ask my questions, I think it's important to put where we're at in a general context, Mr. Chair. My colleague, Mr. Chambers, just spoke, and I don't know him very well. Actually, I don't know him at all, but he has a very good reputation on our side of the bench. He's seen as someone who's reasonable and thoughtful, and the few committee meetings here at Finance that I participated in, he has been just that. But I'm going to have to disagree with one of the things that he said, and it's a pretty serious thing to disagree on. And that is the motives of the government. When he just spoke, he's talked about the government acting here based on political motives rather than substantive concerns about the security of the country and the residents of Ottawa. What we've seen in the past few weeks is it should be horrific to all of us. I hope it is, but for some reason I think when I look across the aisle sometimes it's maybe not, and that's a deep concern. I think that when you have an entire city that's been the capital city of this country, no less, laid under siege, neighborhoods blocked off, people unable to get to work, seniors unable to get groceries, families unable to take their kids to school and unable to get to work themselves, that is an enormous concern. And when our borders are blockaded, that is a serious concern also about the sovereignty and security of the country at large. Not to mention the fact that the organizers of this convoy were calling for no less than the overthrow of a democratically elected government. Each of those points relates directly to the act because their existence indicates that the invocation of the Emergencies Act was indeed just, was indeed the right thing to do. This was a public order emergency. And I would hope that we can, if we're going to disagree on things, as we naturally will, I would hope that we agree on the security of the country and the need to do anything and everything we can to ensure that convoy organizers like Pat King, for example, are not allowed to set the narrative on this. And I still think that there are colleagues across the aisle in the Conservative Party that maybe we can find a way to agree on. Maybe we can find a way to realize moderation and work with them, even
Point
if
of
there's
order,
clear
Chair.
Disagreements on this.
Point of order.
It was the last
Point of
point,
order.
Phil. If you want to raise a point of order, you can.
Point of order.
I think this member has several times pointed out relevance, and I really do wonder what his soliloquy had anything to do with the financial matters respecting the Emergency Act. But he's completed, so.
Yeah, it's not a soliloquy to raise these concerns about the security of the country. In any case, though, I do want to ask the officials, and I'll ask it to the Department of Finance and Justice. As we know, the Emergencies Act takes very seriously the Charter of Rights. In fact, the Charter still reigns supreme. It is still the supreme law of the land. And I just want to know from finance officials and justice officials what that means in terms of their interpretation of the Act, in terms of their work and their departments. Where does the Charter fit, and how does it all work? How does it come together in the end to work as just that, the supreme law, even when we haven't the Emergencies Act invoked? Go ahead.
So, it's Samantha from Justice. Perhaps I might start, and my colleague Isabelle can follow up. I would offer, so the War Measures Act, which was in place and was replaced by the Emergencies Act, didn't contain the express provision indicating that the Charter of Rights and Freedoms applies notwithstanding the invocation of an emergency. But I think, as we all know, the Charter of Rights and Freedoms applies to all governmental action, from the creation of statutes, regulations, all the way through to its implementation. And so the assessment of whether a governmental action complies with the Charter of Rights is an ongoing I would offer daily occurrence for all government officials. The Emergencies Act makes it explicit because of its predecessor, but it doesn't actually change how we do business. And so all of the measures throughout both the emergency measures regulations and the emergency economic measures order were drafted with the Charter of Rights in mind. And to the extent any right has been limited in any way, it was done with respect to either the Section 7 analysis or with respect to Section 1 and the proportionality to achieve the objective that was sought to deal with the unprecedented events.
Thank you, and thank you, MP Fragascatos. We are moving to our fourth round, and I've got the Conservatives up. I do have MP Chambers. I'm not sure if that is still the same list, but MP Chambers up for 5 minutes.
Mr. Clerk, or Mr. Chair, I'd pass my time to Mr. Stewart if he has questions. If not, well, why don't I ask one, and I can split my time with Mr. Stewart if he's ready. Question for justice officials. Are there other laws and statutes that allow for the bank accounts of individuals to be frozen?
I believe the statute administered by FINTRAC would allow some freezing, but I will pass the floor to my colleague Isabelle in the financial sector.
Yes, no, the legislation, the FINTRAC legislation does not allow for the freezing, but certainly on an ongoing basis, as you may know, police forces doing investigation when there are illegal activities certainly deal with financial institutions, and accounts are frozen on an ongoing basis if there are irregularities, fraud, theft.
Okay, so perhaps a more finer point. There are other avenues through which individuals may have their accounts frozen, correct?
Currently, yes, that is correct. There are other avenues but not that would cover the specific events that required the Emergencies Act to be activated.
Okay, I mean, the provincial government had accounts frozen without using the Emergency Measures Act. So is it the judicial opinion of the individuals here or the government that there was no other way to freeze an individual's account other than invoking the Emergencies Act?
Well, I will leave Samantha speak to the legal views, but certainly it's not that the federal government thought there was no other venues to freeze the accounts. There's no other venues to freeze the accounts in view of the current illegal blockades that were ongoing and the fact that we had to take extreme measures to freeze the accounts to basically discourage people to fund illegal activities.
I mean, that's an interesting answer. I hope we'll get some clarity on that. I suspect we will. I mean, one of the issues with the Emergencies Act is that there are no other avenues the government could have taken. So that's an interesting response. I will yield my time to my colleague, Mr. Lawrence, for the remainder.
Thank you very much. And I just wanted to get some clarity, or just to just so Canadians can understand, and I can't be the only MP, and in fact I know in our caucus it's almost throughout, that received many phone calls and many emails of very, very concerned and scared Canadians. And so if we can provide some clarity. So you've already filled in some spaces, and I want to fill in the rest. So if in fact you supported the convoy or you were present at the protest from February 15th to February 22nd, there is a possibility your account could be frozen. But if you made a financial support or any other type of support, or were even present at the protest in Ottawa before 15th, your bank accounts shouldn't be frozen. Is that correct?
Prior to February 15th, should not have been frozen. That is correct.
So it's really just individuals who supported or were present in the Ottawa protest between February 15th and February 22nd that should be concerned.
Those were the ones that were involved in those activities that are prohibited by Section 2 of the regulation. That is correct.
Okay. And so because we've stopped freezing bank accounts, anyone whose account has not been frozen, we can say that it will not be. Is that correct?
It will not be frozen to the extent that they do not start funding other illegal activities that are prohibited by Section 2 to 5 of the emergency measures regulations.
To your knowledge, are there any of those activities going on right now?
Not to my knowledge, but I believe the RCMP would be better placed than me to have that information. I do not.
And I just want to follow up with my comments from Mr. Blakey. Is there anything stopping you from asking the financial institutions to sending notices out to people who have their accounts frozen for Emergency Act? Is there's because I don't believe there is. I'm a lawyer. I don't think there's anything asking them, because there are. I can't tell you how many Canadians. I had an 80-year-old gentleman call me and say, "I'm not sure if I'm going to be able to eat tomorrow because my account might be frozen because I gave $50 to the convoy when it was legal." They're terrified out there. There's got to be something you and your department can do to alleviate this fear.
Well, I think
very
it's
short answer, please.
It's certainly something that we should consider. But thank you for offering that suggestion.
Okay, thank you, MP Lawrence. That's a time, and we are moving to the Liberals. MP Zarowitz for 5 minutes.
Thank you so much, Mr. Chair, and I want to thank all our witnesses for their longevity and for being so patient with answering all of our questions. I want to just dispel a couple of things, just because I think it's important to. I believe that one of my Conservative colleagues earlier said that there was a complete suspension of civil liberties. And so I just want to make sure that everybody is very clear that the enactment of the Emergencies Act requires that the actions undertaken under our public order emergency to be charter compliant every step of the way. And we have had that confirmed at this meeting. I think there's also been, and I think that Mr. Lawrence was a little bit on this track, that little old ladies and sort of the general public are being impacted. And so in terms of their accounts being frozen, and I just want to make sure that I read into the record something from an article that the Globe Mail had written, and it said the RCMP, banking sector, and federal government said Monday that account freezing powers bestowed under the Emergencies Act to help authorities deal with the convoy protests do not affect donors to the protest, despite unsubstantiated claims by Conservative MP that a constituent had her bank account frozen over a $50 contribution. At no time did we provide a list of donors to financial institutions, the RCMP said in a statement Monday. The agency said that while it had sent financial institutions a list of accounts to monitor and freeze, those accounts belong to individuals and companies suspected of involvement in illegal acts, such as influencers in the illegal protest in Ottawa and vehicle owners and drivers who did not want to leave the area impacted by the protests. I just want to make sure that we have that on record. I do not want anybody out there being terrified that their accounts are about to be frozen, or that there's all these Canadians who have just their accounts willy-nilly and frozen. So important to put that on the record. I also think it's important to state the following. This is from a speech from our Deputy Prime Minister and Minister of Finance. She'd indicated federal government institutions will have new broad authority to share relevant information with banks and other financial service providers to ensure that we can all work together to put a stop to the funding of these illegal blockades. This is about following the money. This is about stopping the financing of these illegal blockades. And today, she says, we are serving notice. She says the Canadian economy needs them, so them being sort of all of those that were involved in the blockade to be doing legitimate work, not to be illegally making us all poor. We also heard excellent responses from Ms. Jacques today that has clarified that we did have gaps in terms of the fact that FinTrack and the RCMP were not able to collect data from both the crowdsource platforms, crowdfunding platforms, as well as cryptocurrencies. We have also indicated that we're going to be introducing legislation to make this permanent. We've also heard that federal government
is not personally collecting the data. It is that we've enabled that information to actually go directly to financial institutions and RCMP for them to take actions. And so I just want to make sure that we put that all on record. It's important for us all to be clear about where we are at. And so my first question is actually to follow along the lines of Mr. Fragiskatos after his soliloquy when he talked about confirming the compliance of the Emergencies Act and public order emergency to be compliant with the Charter. I wonder if I could have Ms. Dixon talk to the other key difference, which is that there are accountability measures that the Emergency Act imposes. And can you maybe describe some of these, please?
Absolutely. Thank you very much. So specifically with respect to the order and the regulations themselves, the Emergencies Act provides that members of both houses of Parliament can actually move motions forward. So to the extent there was a desire to see amendments made, that is a possibility that is enabled by the Act itself. Further, there's a parliamentary review committee that is established and has some timelines to do certain things. I won't take up your time with the specifics. It is set out in Section 62 of the Emergencies Act itself. And then finally, when the emergency would be revoked or expired, there is an inquiry that needs to be put in place that will look into the circumstances that led to the emergency being declared and the response.
Thank you. And thank you, MP Zurowitz. That's the time. We are moving now to the block and Motion Samari for 2.5 minutes.
Merci, Monsieur.
Thank you, Chair. My questions are for the Department of Justice, Ms. Maislyn Dixon or her colleagues. When we look at ordinary laws, we've got the Criminal Code and we've got the Act on Proceeds of Crime and Terrorist Financing, which ban financial crimes and money laundering or the funding of criminal activities. So according to you, do you believe that the regular laws allow us to prevent direct or indirect funding of an illegal activity? That's the question. The regulation that's been set up specifies what we mean when we refer to an illegal assembly that would be considered to be criminal in nature. So we've made this more precise, and so there are links with offences that has now been made very clear for Canadians. So basically you're saying that the rules that are in place, the municipal rules and the criminal code and the highway code did not recognise the occupation in Ottawa as an illegal activity. No, that's not what I said. Sorry. What I was specifying was that there were specific details that were added in terms of what would be considered to be an illegal assembly with a very specific, well-defined criteria in Section 2 of the regulation. And according to the Department of Justice, with the regular laws, would it be possible to indicate that the occupation in Ottawa was a criminal activity? There were certain elements, no doubt, but when the declaration took place, the government examined what they were faced with and took the necessary measures to put a stop to that. So I'm going to try and put my question again. Before the 15th of February, the occupation of Ottawa could not be perceived as an illegal activity. The necessary measures to put an end to that had not been taken, and so there were emergency measures that were implemented and they were considered to be necessary. Well, it seems that we're trying to avoid the question. The occupation of Ottawa with the regular laws in place, could they be perceived as an illegal criminal activity, yes or no? Yes, there were certain elements that were attached to crime. Thank you very much.
That's the time, MP Samari, and we are moving to the NDP. MP Blakey for 2.5 minutes.
Thank you. So we know that a number of donor names were revealed due to an anonymous hack, and they were posted online. would that be sufficient under the order for financial institutions if they receive that information, or if they, staff of a financial institution saw those names leaked? Would that be sufficient under the order to create a duty for them to freeze accounts, or would they, or not, I guess is the question? Would they have to consult law enforcement first in order to get an adequate determination as to whether or not people were actively supporting the convoy beyond the content of the hack?
I must admit, I'm not aware of the release of that hack that you're referring to, but what I can tell you is financial institutions were very concerned to ensure they take the proper steps to satisfy themselves that the people, if they took the decision to freeze their account, would be people that were designated persons and that they were involved in illegal activities. So I think they would, just on the face of the names, I would doubt, but I cannot speak for them, that they would just take action. I think they would need to satisfy themselves. And again, I'm sure they would consult their legal team to ensure that they meet the requirement of the order prior to taking action.
Has there been any direction or counsel given by government to financial institutions as to what kind of information they can retain or should retain, or whether they should destroy information, or how they should treat people on a go forward basis after the resolution of the emergency that precipitated the use of the act?
I've not had such discussions. I mean, the information that was provided pursuant to the order was prescribed by the order. Information was shared between maybe law enforcement and the financial entities, and I'm sure they will abide in accordance with laws that are in place with respect to retention of any information they may have. But
can I get your opinion both as to whether it's possible and whether it's advisable for government to issue any such direction, including whether there'd be some legislative action required to give a clear expectation to financial institutions as to how they should treat the information that they may have received from law enforcement or elsewhere, and what they should do with information on people's file, so that it would not affect people on a go forward basis in terms of their personal financial business?
Short answer, please.
Certainly a question I would like to take back and consult with our Department of Justice on
could you, once you've done that, could you then give us a response in writing to that question to the committee, please?
I can consider the question, yes, and see what response we can provide. Yes.
Thank you, MP Blakey. We are moving to the Conservatives. MP Stewart for 5 minutes.
I think, Mr. Chair, MP Stewart's having some technical difficulties, so we'll just do a little bit of tag team here. So I'll
MP Chambers.
That's okay. Thank you very much, Mr. Chair.
Yep.
I fully recognize that we're in a bit unprecedented times on a whole host. I mean, it's a very overused words, but the first time we're working through this legislation, it would be very helpful for the committee as we're discussing or contemplating any recommendations or future uses of kind of either process map or flow chart at a very high level that discusses or outlines the flow of information between the RCMP or other sources of information before it gets to a financial institution, so that we can understand who touches certain information, where it ends up, and then where decisions are being done. I think we've had some great information today from our officials in terms of, the banks are making these determinations based on some information provided from the RCMP, but it would be, if this was documented perhaps in written form, I think would certainly help us or help me as a member of the committee, and I hope others, as we consider any recommendations about process going forward. Is that something we could ask of our officials?
Certainly on the sharing of information that is shared by the RCMP with a financial institution that would be best placed to map this out, but we can, certainly consult.
Okay, That would be fine. Just to the best of your knowledge, how does at a high level, something gets flagged, it moves over, how it kind of goes through the process and ends up with a financial institution. And I hope we'll have opportunities. I suspect we'll have opportunities to hear from the financial institution themselves in terms of their own internal processes, but with respect to the government, that would be very helpful.
Yes, that is a good point, because they also have their internal processes
Yes.
and they rely on those to also obtain information that was helpful for this order.
Yes, these algorithms that are a bit of a black box, and I'm sure we'll learn more about those as well, and that we don't have any line of sight into. The Minister of Finance today stated, and this is a quote, "As of today, a bank or financial service provider will be able to immediately freeze or suspend an account without a court order," implying that I think this can happen in previous times with a court order, which allows for individuals to make representations on their behalf. The executive director of the Canadian Constitution Foundation has written that this sounds like an invitation for banks to arbitrarily seize property of suspected involvement without any built-in recourse or ability to apply for reconsideration. The testimony we've heard today from these witnesses, and thank you very much for being forthcoming, is that there is the possibility for reconsideration after the fact. I just would like to confirm if that's your understanding.
It is my understanding if an account is frozen and the person finds out, of course, realize the account is frozen, that they can and get in touch with the financial institution. And as we explained, there is a duty to determine on an ongoing basis. So the financial institutions have to review on an ongoing basis the situation and address it. So the nature of the suspension or freezing of the account is a temporary, right? This is an extreme measure and can be, as we've found out, these accounts can be unfrozen fairly rapidly.
Okay, thank you.
There's a proper determination.
Thank you. So 2 quick questions on that does this end up like a no-fly list where somebody's now asterisked for the rest of their life? And then second question, the follow-up would be, for those accounts that have been frozen, are these accounts that are limited to the individuals under investigation? I'm thinking of circumstances where there are a number of, say, joint accounts, or perhaps someone's a power of attorney for, their parents' accounts, and all of a sudden, because one individual who has been subject, is it now possible for these other individuals to have their accounts and financial services impacted?
Yeah, I would say it's quite different than the Passenger Protect program that was in place, which has different processes. This is temporary, extraordinary under the an order under the Emergencies Act, and can be revoked and changed fairly quickly. With respect to accounts, I mean, a number of accounts can be affected, including joint accounts. With respect to those for which you have.
That's okay.
Yeah, thank you, MP Chambers. That is time, and now we are moving to the Liberals and MP Diab, and welcome to the committee, MP Diab.
Thank you very much.
For 5
This has
minutes.
been a fascinating afternoon. Witnesses, thank you very much for the opportunity to hear from all of you. What we've gone through the last few weeks, for me personally, has been a shock to my system, and I can say it's a shock to many people who witnessed it. I've got a couple of questions, but I just want to finish off where you started, Madame Jacques. On the one point is, I think we talked about 200 plus bank accounts that were frozen out of, I forget how many thousands of donors, and how many donors was that? I believe it was in the Globe and Mail or something like that. But if there's overreach, one would assume, well, I don't know. I don't want to put words in your mouth, but did you say it was 200 and some over all of Canada, over the thousands and thousands of people that we saw illegally protesting, blockading, whatever, that were frozen out of how many dollars amounts? And to is my heart goes out to anybody that really thinks that, if they put $20 or $50 or, in good faith to a good cause, that they could be somehow held liable. And you really are reassuring me in hearing you in the last couple of hours that that is not the case. If erroneously it happens, it should and could and would definitely be overturned by simply contacting the bank, and taking care of that. I practiced law. It's been now about 10 years since I've not practiced law, but before that I practiced over 20 years. And I know certainly in matrimonial law, all kinds of frozen bank accounts happened there. So, there's all kinds of situations where, they get frozen and so on. And there is a mechanism if there's an error or so on. But can you go back to that point again and just reassure us one more time, please, so that these people that in good faith did something good across the country to really help, something that they thought was the right thing to do, that they're not caught. And specifically, from what time frame, would that have taken into effect?
Now, if people in good faith were making donations prior to, knowing that the order was in effect, and prior to the situation degenerating to the point that it did, certainly they were not captured, because there's no retroactivity, as you point out, to the order. And it was only from a point forward from February 15th. And certainly all I can say, in our discussion with financial entities that we had in the past week, certainly that was not the target of the activities, certainly not the target of the list provided by the RCMP. Is it possible that somebody was captured? It's always possible because the order provides for it, but I doubt that we'd have many of those cases. And to go back to the numbers that you're asking about, the numbers change all the time, and I'm sure they're lower today than those that the last ones I have as accounts have been unfrozen on an ongoing basis since yesterday. But the last number I had was over 206 accounts, but it's a smaller number of people because some of these persons have more than one account. And the total number, the value was, the last number I had was $7.8 million.
Right. Merci pour la réponse. Now, I want to go.
Thank you for that answer.
Moment for whatever time I have left. I heard a lot, and I heard all the debates, most of them, whether I was actually supposed, whether I was virtual, thank God for that. But I heard a lot of them, and a lot of the debates also concentrated on this predecessor or the so-called predecessor to the act. Can please, justice officials, please, in plain language, I would say English, and the translation will be in plain French, the differences between the predecessor War Measures Act, which dealt with war and military and so on. And I come from, a place in the world where I see military, unfortunately, but, and the current act, please. And the relation of that to our charter and what rights do we have as individuals, and just differentiate that or make similarities, please.
In a short answer, please.
Very, very shortly. So the Emergencies Act passed in 1988. The Charter came into force in 1982. It applies. So any governmental action, be it the statute, the regulation, the implementation must be compliant with the Charter. The War Measures Act was a different statute. And to be very explicit about it, the Emergencies Act included a specific reference to the fact that the Charter of Rights and Freedoms would apply.
Thank you. And so MP Diab and members, we are moving to our fifth round. This round will be our final round, where we will conclude with the witnesses for today. And I'm going to divide, as I normally do when we come to this time, and I look at how much time we have left, I will divide up this round equally amongst the different parties. So it'll be 3.5 minutes for each party. It'll start with the Conservatives, and I don't have here who's speaking first for the Conservatives or who's on the list. So if you can help me out.
Thanks. Thanks very much. Mr. McLean, did you want to take the round there? Sorry, I know you've just arrived, Greg.
No worries. Yes, I would like to take the round. I hope I'm not asking questions that were previously answered, but and I apologize for not being here for the previous session. But yes, if I could, that would be worthwhile. May I start? Okay. The questions I have, I mean, I look at this nature, and I'm glad you brought up the charter on this, but the whole nature of actually expropriating or freezing somebody's bank account is effectively shutting them out of their ability to transact in society. And, you know, going to friends and families and effectively getting help that way. Is that you don't think that's an overstep of what the charter provisions are as far as, you know, freedom to transact being one of our fundamental freedoms?
So if I may, Isabelle, the measures have been tailored to limit the impact on the charter rights, no more than reasonably necessary to end the unlawful assembly. And the obligation to freeze accounts only applies to people who are participating in the illegal activities that are described in sections 2 to 5 of the Emergency Measures Regulation. And a person can regain access to their assets by stopping their participation in those unlawful activities.
Yeah, but it doesn't say how. And it doesn't say, in the description about being involved is rather broad if you look at it. So it could be anybody that, as we say, gave $50 to their son to go and, you know, protest his right. Is that not so?
So I might pass the floor back to my colleague Isabelle. It was effective as of the date the regulation was made. So as of the 15th of February, anything that occurred prior to that date is not captured. There's no retroactivity to this regulation at all.
Okay, so of the two, so I'll go back to Isabelle then, pardon me. So the 206 accounts we're talking about here were all money that gave, or all funders, Canadians that gave funds through Give, Send, Go after February 15th?
I don't know through which means that they gave money, but certainly money that was in the possession of the financial institutions covered by the order after February 15th. That is correct. And we were discussing.
So sorry, I don't know if the feed is bad at my end or at the other end.
No, I was just going to say that in previous discussions that we've had throughout this meeting, what we were saying is in view of the information that has been shared by the RCMP and the view of the fact that the goal was to stop unlawful funding illegal blockades, the unlawful assemblies, it would seem rather rare if somebody had given $20 and would be captured by or would have an account seized in view of the information.
And yet that is the way it's written.
That is the way it's written, and it's very possible. But what we discuss is that the main purpose and goal was to ensure that we'd stop the funding for the illegal blockades. Yeah. It is certainly possible.
Thank you.
And I appreciate that.
Thank you, MP McLean. I appreciate that's the time. We are moving now to the Liberals for 3.5 minutes, and MP Chattel.
Thank you, Mr. Chair. Look, again, this has been a very helpful discussion because, like many MPs around the country, we were flooded by fear, and hopefully we could return to our constituency's office in response to those calls and say, look, if you have donated before February 15, your account won't be frozen. But moreover, for a financial institution to freeze the account, they need the information that you participated to a blockage that you used that money for such a reason. And again, we all have the statement can link to my conservative colleague of the RCMP that says the list that was provided to financial institutions included identities of individuals who were influencers in the illegal protests in Ottawa and owner or drivers of vehicles who did not want to leave the area impacted by protests. At no time did we provide a list of donors to financial institutions. So I think we have a responsibility to reassure the population in this area. Now, one of my main concern is about the source of the funds in those crowdfunding platforms. I'm extremely worried when I hear, because of the leak, that the money, millions of dollars, and half of the donation came from the United States or other countries and anonymous sources. So half of the donation from the US. I know right now we have a gap on the notion of finding the ultimate source, the beneficial owner of an account here in Canada. We don't have our registry and it won't be ready before 2025. I welcome the amendment in last year's budget, but I'm extremely concerned how, Madame Jacques, a question for you, how can we, if we do have the information, can we trace back the money to the beneficial owner of this account in the US?
To my knowledge, not currently. And I do not know if on the phone I have a colleague that would be able to give you a better answer that I have. I don't know if Manuel or Julien Brazeau is on the line.
Monsieur Brazeau, no, he's not there.
Oh, hi there. I am.
Hello.
Sorry, just had to get off of mute. Unfortunately, no, we don't have. I mean, you know, I think FinTrack would be likely in a better position to know in terms of the sort of origination of funds. But again, they get information or transaction reports where there's a suspicion of potential money laundering, or when individuals are making large value transactions. So they may have the information, but we at the department wouldn't have that line of sight in terms of where those funds originated from.
Mm-hmm. So we have identified in this Emergency Act several gaps in our legislation. So what is the Department of Finance doing to what are the concrete steps that we would have to do as a government and you as a department to fill those gaps?
And a short answer, please.
Julien, if you may.
Sure. So just briefly, I think, you know, and Isabelle spoke to this before. I think the major gaps are sort of information gathering gaps, and that's what we're trying to address by working on regulations that will capture, you know, crowdfunding platforms and payment service providers with a view to having a better line of sight in terms of where the flow of funds are coming from and to what ends those funds are being used. And so those are measures that I think the government has announced it wishes to make permanent. And as Isabelle said, those we're working on those at the moment.
Thank you. Thank you, MP Chatel. And we are now moving to the bloc and MP Sainte-Marie.
Merci.
Thank you very much, Chair. I have a question for the Department of Finance and Ms. Jacques or her colleagues. The financial institutions under the ordinary legislation are used to freezing accounts because of financial fraud or money laundering or illegal activities, and then the financial institution has to inform FinTrack and wait for their green light or their answer before they can unfreeze these accounts if needed. So I'd like to repeat that once again, this is when we apply the regular laws that exist. However, with the order, it's drafted in quite a vague way, I believe. So I'd like to know whether the government and the department has given clearer instructions or direction to FinTrack to deal with the freezing of these accounts. Thank you. No, in fact, FinTrack is not authorised to freeze or unfreeze certain accounts. That's not part of their mandate, and no doubt you'll have an opportunity to talk about that in more detail with them when they come to testify on Thursday. It's not their normal role, nor is it their role under the current order. I don't know, Julien, if you'd like to add something. No. I'd just like to say, yes, absolutely, there's no communication between the Department of Finance and the FinTrack And we do not give any direction in terms of freezing of accounts because it really does not fall under the scope of their mandate. Well, thank you very much for that answer. And I would like to take this opportunity to thank all of the officials from the departments. You've done incredible work and we've gathered a great deal of information today. So sincerely speaking, thank you very much. I'm going to use the rest of my time to make a comment to my colleagues on the committee. For some days now, in the chamber, we've been looking at the order and the Emergencies Act, and in the light of our work today and what we've seen in the House and all the information that we've received, my concern was to see whether the fact that the government hadn't acted in the first few weeks of the occupation then wanted to make a big splash with the emergency order to show citizens that they're being proactive. But up until now, I haven't seen anything that convinced me that we absolutely needed to launch the nuclear bomb of the Emergencies Act. And I believed all of that could have been covered by standard legislation. So from my point of view and from the viewpoint of the Bloc Québécois, it's a communication exercise which I think sets a dangerous precedent, and I'm sure that the further work of the committee will allow to shed more light on this so that we can deepen our analysis of all of this. And that rounds off my comments for today. Thank you.
Merci, MP Sainte-Marie.
Thank you, MP Sainte-Marie.
Our last questioner is going to be NDP MP Blakey. So for 3.5 minutes, please, MP Blakey.
Thank you. And I'm going to, I would repeat comments that have been made earlier, just to the effect that we really are in uncharted territory with the use of the Act. And so it's an important test case. And I think there are a lot of lessons that we need to learn. It's incumbent upon the committee to be able to make good recommendations about what we have learned from this and how to ensure that when powers like this are used, that they're used appropriately and that and they're not used any more than they must be in order to deal with a national emergency. That's why I welcome, I think there's a Civil Liberties Association already that's challenging the use of the Act. I welcome that test. I think it's appropriate that these things be tested in court. Now, for Canadians who have had a bank account frozen, who feel that that was inappropriate, that that they had nothing to do with the convoy, for instance, one of the things that they need, and this is why I've been talking about the importance of a notice, letting people know that their account was in fact frozen under the authority of the Emergencies Act. They need to know that that's why their account was frozen, and then they need resources, obviously, in order to be able to challenge that. So I'm wondering what thought government has given and what the plan is for Canadians to be able to pursue this after the fact if they felt that government got it wrong in flagging them to financial authorities and that they weren't dealt with appropriately under the emergency orders. What recourse will there be for them? Who would be held responsible if there was a successful court case that found that they were inappropriately flagged?
Well, as we discussed before, certainly the issue of notice is something that we will take a look at. Certainly in view of the extraordinary nature of the Emergencies Act and the steps that had to be taken rapidly to stop the funding of illegal blockades, it was felt that the Act as drafted, meets the charter requirements, that there's an ongoing requirement to review the information that a financial sector has, institutions have in their possession, and that there's a quick possible resolution to an account being frozen. It was either the person seizes the illegal activity, returns home, advises the bank, and the account can be unfrozen fairly rapidly. And if it's a case of mistaken identity, the same thing. A quick discussion with the financial institution and verification of wrongful identity, and the account can be unfrozen quickly. So I think that in view of the way it's been set up and the positive obligation to review on an ongoing basis, we felt that the persons were well protected.
And If I may just add, draw your attention to section 47.2 of the Act. So while persons can be subject to immunity, the Crown does remain responsible pursuant to the Crown Liability and Proceedings Act. So should there ever be a case where damages were to be awarded, the Act provides that the Crown is ultimately liable.
Okay, so there is an avenue for Canadians to pursue remedies if they feel that they've been treated wrongly under the law. And is there any? I know we have the court challenges program. Would that be a kind of suitable place for Canadians to go for resources in order to be able to challenge these things in court, or is any other kind of support for challenges to the use of these powers being contemplated by government at the moment?
And very short answer, please.
I don't feel myself comfortable to suggest how folks should seek legal advice, but there are various mechanisms out there that people can access.
Thank you. And thank you, MP Blakey. That is the time, and this is also the time. And
point of information, Mr. Chair.
Yeah, MP Chambers.
Thank you very much, Mr. Chair. I know we were saving 15 minutes for discussion of the motion, but there have been some discussions behind the scenes with the parties. I believe there will be a unanimous consent provided for an amended motion. Since I took some time from my colleagues earlier discussing the motion, if it's okay, if the rest of my colleagues, if we wanted to offer both the Bloc and the NDP some additional couple minutes, if they had any additional time, that would be an offer we would be willing to make, if that's okay with the rest of the committee, as we have our witnesses here.
Clerk, just if you could let me know if we have UC, and thank you, MP Chambers.
Certainly have no objection to that, Mr. Chair.
Okay. I'm sure you didn't. So
I don't want to.
Are we good with UC? Clerk?
Well, I don't see any objections myself, sir.
Okay, so we've got a little bit more time. We can, so the Bloc. And is this for everybody, MP Chambers, or
no? That was just for the Bloc and the NDP, since they always get shortened. Since they get shortened.
Well, they got equal time in this last round, but okay. MP.
They have final comments. And I have
a final comment.
I have circulated the updated motion for everyone in their P9, so that is available for us to review as the final comments come in. Thank you.
Thank you. MP Saint-Marie, any final comments? And then MP Blakey again with final comments.
Yes, just a quick question for Ms. Jacqueline. When it came to the proclamation of the order, what were the ways in which you informed the financial institutions of this? I'm thinking of the big banks in Toronto and so on, and also the cooperatives and the Desjardins Group. How were they informed? I think that the big banks were aware of this. We communicated with them to have discussions, and we included the big banks and Desjardins to talk about the order and to answer any questions which they might have about the enforcement of these new measures. So they had sufficient time to put their questions, the big banks and Desjardins, the other institutions? Yes, certainly. Thank you very much. With pleasure.
Merci, Monsieur Saint-Marie.
Thank you very much, Mr. Saint-Marie.
And I guess just following up in that same spirit, I mean, for folks that bank with financial institutions like credit unions out here on the prairies, like what opportunity would smaller financial institutions have had to get clarity on what their obligations are and how to act appropriately under the orders?
Yes, we had a similar discussion last week. I think we had over, and Julien can correct me if I'm wrong, but certainly over 620 people participating in an information session to answer questions they may have on the application of the order.
Okay, so that would have been made available.
Yes, it was made available
to credit unions across the country in addition to big banks.
Absolutely. We had a lot of person interested in asking questions.
Okay, thank you.
Okay, thank you, MP Blakey. And yeah, great questions and answers. And this is now the opportunity to thank the witnesses for coming before us as we study the Emergency Measures Act, and for all their great testimony on behalf of the members and the clerk and the analysts and the interpreters and the staff and everyone else. I hope I've not forgotten anybody. We do thank you for being with us here today and for joining us. And you're free to go at this time. I say to the witnesses, we thank you all.
Thank you.
Thank you.
Okay, clerk, you just let me know when. Okay, the witnesses are gone.
Yes.
So MP, so we do have the motion. I guess it's been. And listen, members, I apologize wholeheartedly on this. I know I've been holding my phone this whole time and jiggling around and trying to keep it as steady as possible. And so my apologies to all of you. We do have MP Chambers' motion, and MP Chambers, do you want to first discuss your motion?
Yes, thank you very much, Mr. Chair, and you did a fantastic job under the circumstances. I know that Mr. Samery would have done just an excellent job, but we're glad that you joined us. You were able to rejoin us. I did circulate an updated motion. This does reflect comments from all parties. And that is certainly welcomed in the spirit of collaboration, of course, and we're trying to move quickly. But I can read it into the record because it is shorter, which is nice.
Point of order, Mr. Chair. I'm sorry, Mr. Chambers.
Point of order.
I've reason to believe that perhaps not all of members have received it. I just want to make sure that all the members have received this amended motion.
Apologies. I did circulate it to the clerk. Perhaps he can make sure that you receive it, but I'll read it in the short term, and we'll make sure that you get that in your account. So that for as long as the Emergencies Act financial requirements are in place, that the RCMP, CSIS, CBSA, Public Safety, and FinTrack provide a weekly report to the committee of the total number of persons and accounts they have flagged or requested to be frozen by regulated financial institutions, and that all federally regulated federal agencies provide a similar weekly report of the total number of persons and accounts that have been frozen using Emergency Act powers. And finally, that this information be provided in a manner that respects personal privacy, national security, and operational security, and that the first report be due to the committee on the 2nd of March, 2022. And for greater clarity, one report on behalf of the government would be satisfactory. I think what we're looking for in this committee would just be, the number, right? So as we track this number, we may wish to revisit additional requests for information, but I believe if you will seek, you'll find we have unanimous consent to accept this motion.
Okay, well, thank you, MP Chambers. Just want to check quickly with the clerk if it has been distributed, clerk, to everyone.
There were quite a few names missing from the distribution of Mr. Chambers, and I have forwarded it to the names that were not on the distribution. So if there are MPs in the meeting right now who do not have it, please let me know and I will circulate it. I had one question for Mr. Chambers. So when you read the motion near the end that all federally regulated federal agencies you read, or is it financial agencies?
Apologies, regulated financial agencies provide a weekly report.
Perfect. Yes. Mr. Chair, Ms. Derowitz had her hand up and just lowered it. There's no one who has their hand up right now. Mr. Fragiscatos rose his hand?
No, it was the same question. Okay. Federally regulated financial, federally regulated financial agencies, correct?
That's correct.
Okay, great.
Okay, thank you, MP Chambers. Just discussion. Clerk, no hands?
There is Ms. Chattel who just raised her hand.
Okay, MP Chattel.
Yeah, a point of clarification, Mr. Chair. I just wanted to know what it means as long as the Emergencies Act financial requirements are in place. Do we mean while the Emergency Act is in effect? Thank you, Mr. Chair.
Merci, Madame Chattel.
Thank you very much, Ms. Chattel.
That would be an appropriate interpretation, Ms. Chattel.
Okay. And clerk, again, I'm flying blind, so if any other hands.
Yeah, Mr. Blakey's hand is up.
Okay, MP Blakey.
I just wanted to thank Mr. Chambers for bringing the motion forward. I think this is good oversight information. I think part of the important thing that it would allow us to do, we've heard today that these powers are really only meant to have been used to freeze accounts for the period really from February 15th to February 22nd, that the RCMP have or ought to have directed a lifting of all account freezes so far. And I think this would just give us the opportunity to get that reporting and be able to track as a committee. There are any other frozen accounts beyond the initial report in the period going forward, then that will be an important prompt for us to begin asking questions and maybe hear again from some of the officials. Okay. So, I think this is a good piece of work and a good contribution to the oversight work that we can provide as the Finance Committee of the House of Commons.
Okay, well, thank you for that, MP Blakey. And I'm not sure if there are any further hands, Clerk.
Mr. McLean has his hand up as well.
Okay, Mr. McLean.
And yeah, I apologize. I'm coming here. Instead of agencies are usually government institutions. Should we put entities in the last sentence there? Be friendly. So it says that that all federally regulated financial agencies provide a similar weekly report. Should we put entities or?
So long as my colleagues around the table don't object to that amendment, I think that would be greater clarity. Yes.
Members?
There is Ms. Koutrakis and Ms. Derowitz.
Yeah.
Ms. Koutrakis, yeah.
Yeah, if I may, Mr. Chair, instead of entities, would it not be more sound to say institutions, financial institutions?
Correct.
Who said that, Clerk?
Madame Koutrakis.
It was me, Mr. Chair, MP Koutrakis.
Yeah, but then somebody said correct. I'm not sure who said that.
Sorry, it's Mr. Chambers with the motion. So I kind of accept that as
okay.
a friendly amendment. I think that's appropriate.
Okay.
I see some thumbs up.
Thumbs up.
All right. Excellent. Great to see that. And I do see a hand in MP Derowitz.
No, I was just going to say thumbs up.
Oh, just thumbs up.
Can we just put this to vote, perhaps? Just
yeah. Well, I thought we had UC on this.
Can we just have UC on this and just say declare it UC?
Wonderful.
Okay. So do we have UC? Yes, Clerk?
I don't see any opposition, sir.
Okay. Excellent, members. Thank you so much. Okay. And shall we adjourn?
Yes.
Thank you.
Okay, fabulous. Have a wonderful evening.
It was so great to see. Salut, Gabrielle. À tantôt, peut-être.
See you later, maybe.